189th session, and we are dealing with the right to indigenous justice for Ecuador, requested by the Confederation of Indigenous Nationalities of Ecuador with IE and the Cotopaxi Indigenous and movement. Welcome, civil society. It's a pleasure to greet all of you. It's a pleasure to also welcome the illustrious state of Ecuador. With me, I have Edgar Estuardo Ralón, Rapporteur for Ecuador, Commissioner Christopher Bulkin, Rapporteur for Indigenous Peoples and Communities, and also the Executive Secretary, Tania Renaud. Before we begin this hearing, I'd like to remind you that the Inter-American Commission on Human Rights is currently celebrating its 65th anniversary. Since 1959, it's been committed to defending and promoting human rights, and thanks to the interest and the pact signed by the states and the commitment of societies that want to give life to the Inter-American Charter and the American Convention. Since 1959, hundreds of professionals have been through this institution, have come through, and thousands of individuals, communities, and peoples have turned to the Commission for protection, justice, and reparations. We are celebrating 65 years of history with over 100 on-site visits with their corresponding reports, over 1,000 precautionary measures granted, and over 750 reports on the merits, 220 friendly settlements, and 377 cases that were sent to the court. And all of this while keeping the victims as the central focus of our work and as our priority. In order to ensure that this hearing is inclusive, we ask all participants to begin their interventions by first stating their name, their position, and the organization or institution they are representing today. And then each time you take the floor after that, we would ask you to, again, repeat your name at the beginning of your intervention so that people who are visually impaired will be able to identify who is speaking. Likewise, we remind you that these hearings have Zoom subtitles, captions available, and you can actually activate them directly from your computer, and you can choose the display size for those captions. And they're also available for those who are following us through our Inter-American Commission for Human Rights channels. Before I give the floor to civil society, I'd like to remind you of the time distribution for the hearing. There will be 20 minutes for civil society, 20 minutes for the state, and then the Inter-American Commission will have another 20 minutes. And we'll have the UN expert from the High Commissioner, 7 minutes. That's Jan Jara, representing South America for the High Commissioner's office. And then we'll have another civil society round, 10 minutes, comments by the state, 10 minutes, and then we'll close. So the floor now goes to the representatives of civil society. Good morning. I'm Alex Topicio Topantahami. I'm the president of the Cotopaxi Indigenous and Country Communities Movement. We are part of the indigenous movement of Cotopaxi, affiliated with Conaye, and we're representing Cotopaxi and the Pansaye people. Ecuador's constitution, in its article, first says that it is a plurinational state of rights and justice, and led by CONAIE. Since the 70s, this has been the project, and it is a true aspiration to be recognized as an intercultural, lay, and plural society. And I want to emphasize the persecution and criminalization of the exercising of indigenous justice. Our Cotopaxi movement in 2021 was able to show 29 cases on the enforcement of indigenous justice. In Article 171 of the Constitution as simply a fallacy or a dream for Ecuadorians who consider ourselves to be born indigenous people. The procedures that are used within indigenous authorities are not contrary to the Constitution. They are not contrary to human rights, much less are they contrary to international instruments. The decisions of indigenous community organizations and institutions are in alignment with these standards. And these institutions must be respected by public institutions of the Ecuadorian state. However, up until now, we've simply had just a dream, a hope that that relevant article will be fulfilled. By exercising indigenous justice, they have told us that, or they have been criminalizing our exercising of this right that we have. And the Ecuadorian state, through Articles 344 and 345 of the Code for the Judicial Function, should recognize that any organization or any judge can determine that indigenous justice cannot be used in order to maintain social peace. And this has not been done. Once the indigenous justice process begins, immediately the victims or those who believe themselves to be victims start criminal proceedings. And in this regard, the judges of the Ecuadorian state begin criminal investigations and try to establish economic sanctions or prison punishments, leaving the leader of the indigenous community in a situation of vulnerability. I will now emphasize a very particular case in a canton in the province of Cotopaxi. The canton is called Salcedo, where a person was acting as the president and issued an economic sanction, and immediately those who believe themselves to be victims started to victimize others, and the Ecuadorian state began a criminal investigation where the president of the community has been investigated and has been sanctioned and sentenced to a year of prison and a penalty of over $8,000. So we believe that this is a very serious attack on our right to plurinationality and indigenous justice and to our collective rights. And saying that indigenous justice has been an alternative to the Ecuadorian state in order to implement mechanisms for justice at this time, currently in Ecuador, where we're going through a serious security crisis, we actually want a mechanism where we can create social justice for ourselves within our country. And we also want to tell the commissioners that autonomy and recognition within the constitutional framework of Ecuador that we should have is actually not something we have in reality. So we want to say that the Ecuadorian state must be responsible in this regard and fulfill Article 1 of the Constitution and recognize that we have an intercultural, plurinational, and lay state. Thank you. Cristina Melo, legal advisor of the Cotopaxi Indigenous Movement. This plurinational Ecuadorian state is defined by recognizing ethnic and cultural plurality, but also juridical plurality as part of our state. And the Constitution, based on this Constitution, this court has on several occasions made decisions against Ecuador, since it is limiting the exercise of indigenous justice, and some standards have been established, for example, legal pluralism. I will ask you to speak a little bit more slowly. We have interpretation, and we need to have the two languages, so maybe you can speak a little bit more slowly. So decision 00809 SANCC of 2009, where the Constitutional Court establishes the need for the Ecuadorian state not just to accept the coexistence of multiple legal systems, but also to encourage interaction and harmonious development. In 2014, the Constitutional Court recognized, in the case known as La Cocha, that indigenous law comes from ancestral traditions, and it should be established in each of the peoples, and the only limit can be the Constitution and human rights international instruments. In 2020, decision 13413P20, the Constitutional Court reiterated recognition of indigenous justice within legal pluralism, which is part of a plurinational and intercultural state. The court established that the right to exercise their own justice is inherent to the indigenous communities and nations, and their autonomy needs to be recognized in establishing their own autonomous systems that are a reflection of their cosmovision, their worldview, and their own rights. In terms of jurisdiction, this Constitutional Court has referred to and has determined that indigenous justice can be exercised by the people that each community establishes without a need for formal recognition from the state authorities. And they've highlighted the importance of respecting the traditional structures of the governments of these indigenous nations. In 2019, a constitutional decision 00519RC established the heterogeneity that is inherent in indigenous justice, saying that this diversity does not mean that there is any issue in the system. Then 416IE21 recognized that indigenous justice does fulfill the requirement for due process, establishing 3 phases of indigenous justice that in many occasions will have different concepts depending on the worldview and cosmovision of each community. But in jurisprudence of the Constitutional Court, no details have been given in terms of jurisdiction. It says that there is a competence or jurisdiction in terms of the territory. The indigenous justice does have the authority to administer justice within its territory, and it's just a geographical area. It's a space within which the community develops and leads its life and exercises its right to self-determination. So there can be different jurisdiction separate from territory if there's cultural, if it's part of the cultural area. And when there is a doubt in terms of which system to use, the indigenous justice should be used, ensuring its greater autonomy and the minimum of intervention. However, the jurisprudence of Constitutional Court has taken important steps to strengthen the justice systems of the indigenous communities. However, it has also limited the power of ancestral judges based on something that has no grounds. There's agreement 669 of ILO, and in the same decision on the IACHR, there is an arbitrary limitation of indigenous justice in terms of decisions regarding the life of persons. And this has been reiterated in certain cases even by the Constitutional Court, and this has restricted the full exercising of indigenous justice. And there are other facts as well that will be mentioned regarding the criminalization of the authorities that are exercising the right to impart indigenous justice. Good morning, Lenny Zarzosa, legal coordinator for CONAIA. The structure of the indigenous movement has put out a report on 29 cases of criminalization of community leaders due to the fact that they're exercising indigenous justice, and case study has been done for 4 cases, and this allows us to see the contradictions between the 2 justice systems that are recognized in Ecuador. In the first case, we are analyzing the circumstances of a fraud using e-currency, which generated a pyramid structure with several victims that suffered economic damages, all of them part of the Panzalete indigenous community. And the indigenous movement and its entire structure reported this to the state. Nothing happened, so they decided to activate their own jurisdiction. 2 people were prosecuted for this crime of fraud, and integral reparation was determined. But now the state has opened up an investigation against 3 indigenous leaders who were involved in this case, and they are now being investigated for a supposed crime of kidnapping. They simply issued their justice within the indigenous justice system. In the following case, it's a case in the Chamapongo community of the indigenous community of Quichua Panzaleo. A community leader in this case utilized the indigenous jurisdiction and was involved with the suspects, and a community decision was reached. Now the Attorney General of the state issued a decision, and for that reason, that person is being prosecuted for a crime abuse of confidence, and this is something that is ongoing with a possible punishment. Then in Salcedo Canton, Lourdes P., a community leader, was prosecuted for supposedly illegal imprisonment, and habeas corpus was conceded according to 169 of ILO, recognizing collective rights. In the following case, in the La Tobia community in Quito, this community has been struggling for decades because their community, to make sure their community territory is recognized within the city, which is expanding. And they put forth a community resolution that was also recognized by the Quito local government, saying that it is a community territory and it is being invaded. And several complaints have been reported against them by real estate companies. So we can see the complexity of this situation and how difficult it is sometimes for the 2 justice systems to cooperate. But the Constitution says that only the Constitutional Court can revise indigenous decisions, and there's a role also to be played by indigenous justice, as the Constitution says. Greetings, commissioners. Warm greetings to the commissioners. I'm Leonidas Disa, president of CONAI. The Constitutional Court has recognized indigenous justice, but there is a significant number of cases where ordinary criminal justice takes on actions against the communities that are exercising their own jurisdiction according to their rights. These criminal proceedings criminalize the exercise of collective right of the indigenous communities. The security crisis that Ecuador is going through has been having a serious impact on indigenous community, and the Ecuadorian state has not been able to guarantee them the right to security and safety of their inhabitants, and indigenous communities are especially harshly affected by this, and they need to deal with violence and criminality. Indigenous justice is a way that indigenous communities can self-solve their own security problems and take away some of the burden of the Ecuadorian justice system. But this resource of self-defense and self-justice is facing significant obstacles, however. For example, at this time that we are going through so much uncertainty and insecurity, criminality and organized crime, only an organized community that is under the structure of CONAIE, under the nationalities and communities. There are only in these about 10,000 communities, 18 peoples, 15 nationalities. And this is the organizational capacity we have. And that's how we are dealing with organized crime. This is a savings for the Ecuadorian state of maybe millions and millions of dollars. But instead of respecting this right, what is the Ecuadorian state doing? Instead of doing that, they are spending money through the judges and through the Attorney General's office to persecute and prosecute these indigenous communities. So we have 21 collective rights, and we cannot look at them separately. The collective rights need to be taken in a comprehensive way as a whole. The collective rights of the territories of the indigenous peoples in Ecuador need to be applied and enforced in a collective manner. And then we have community guards, a right that we have to self-determination, to self-control within our territories. And these community guards now have been a fundamental element in the defense of our territories, but we've also been stigmatized by the authorities of the government. Currently, we are facing a stigmatization and persecution problem in a systematic way, installing in society the idea that there's an internal enemy or there's terrorism, and they've been saying that criminal acts by criminal bands are the same as an act of territorial defense by our community guards. And we cannot accept this, that in the Ecuadorian state, a segment of society has been able to instill the idea that what we do is terrorism, and they've implemented this discourse that has so seriously hurt indigenous communities. And the various administrations, Lazos, for example, in Decree 730, said that our sacred symbols are ancestral weapons. If we want to use our sacred symbols, they say that because they are weapons, that they have to go through the authorization of the Joint Command of the Armed Forces. And in Decree 730 says that in the armed forces, within their general operations, they can easily mistake a fact or an action that is of a juridical nation by the indigenous communities. They can take that as a terrorist act. Decree 111 on armed conflict internally determines that new threats to security of the state and the monopoly of force is also in tribal groups. If we go to the UN OIT declarations on tribal and indigenous communities, what does this mean? That it would be also indigenous communities. And this is a great concern when we want to exercise our collective rights. So in this process, international organizations should monitor the respect of these rights by the states, and they should demand that they be respected. So what we ask for is the following. We ask the Honorable Inter-American Commission on Human Rights to promote a dialogue between the state and civil society in the Inter-American area to discuss strategies for strengthening the exercising building of their own systems of justice for indigenous communities in the context of the security crisis that we see in several countries in the region. Also, indigenous communities, we reiterate, have organizational capability and self-organization capabilities, and we are making a contribution to the Ecuadorian state with over 10,000 communities in terms of security, and this also means that 10,000 community authorities have helped Ecuador save their own resources in our own cases. Thank you very much. Thank you. Now the Ecuadorian state has up to 20 minutes for its intervention. Thank you. Thank you very much. Chairman, I'm Alonso Fonseca, National Director for Human Rights of the State Attorney's Office. Before we start our intervention, I'd like to congratulate the Inter-American Human Rights Commission on its 65th anniversary. On behalf of Juan Carlos Larrea, our Attorney General, the presence of the Inter-American community in this hemisphere, in the region, has seen the consolidation of a democratic state and continues to see political transformations and a relationship that develops between rights and constitutional advances at the internal level, and also there are conflicts and tensions that are natural in our region. And processing these conflicts and the interventions of the Inter-American Human Rights Commission in order to take stock of how we have been advancing on rights is very important, and these thematic hearings have allowed us to establish where the key issues are, where there has been confrontation initially, but through time, we see that we've been able to develop standardization and regulation processes that are highly important. So this means this is how important this commission is. We'd like to also greet the President and Vice President during this hearing, the rapporteur, Estuardo Ralón, who is with us, our commissioner from Ecuador, and Commissioner Christopher Volken, Rapporteur for Indigenous Communities for the Inter-American Commission, our Secretary, and Professor Jan Jaraf, who is listening to us virtually, and the Ambassador, Dr. Mauricio Montalvo, who's here today, permanent representative to the OAS. For the Ecuadorian state, this thematic hearing is very important. You'll see that throughout the presentation that we've prepared, there are a lot of points of agreement with what we've heard, but beyond talking about regulatory matters or institutional advances, we want to delve more deeply into some of the cases that have been mentioned. Thematic hearings, unfortunately, are not designed for this, but we have taken note of these cases. For example, the one from Salcedo, we have not actually found it in the petition that we received in December of last year. And for that reason, we will probably have to request that this information be relayed to us so we can take a look at this matter regarding the president of the community. Then there's the case of cattle theft in the Quichua Panzaleo community. We also want to look into that. And please send us all this information you have, because we have a very specific commitment within the authorities to make sure that we look into this very carefully.
In 2023, in the United Nations, and we have here Professor Jan Jarach, there was a meeting, a very important meeting in Santiago de Chile. At that meeting, the representatives of different sectors of the world, different areas, got together to think about all the challenges and difficulties and conflicts that exist between indigenous justice and ordinary justice. The Special Rapporteur for the Indigenous People of the United Nations, Francisco Calitzay, was also there. And he said something very important. He said, indigenous people continue to use indigenous justice. The great majority of cases because of their geographic proximity and cultural, and because they can respond to the cases where the state is not protecting them. And facing these difficulties, which are very common in Latin America, a lack of understanding between ordinary justice and indigenous justice exists, but we are making progress, and we're making important progress. Jan Jaraf at that same meeting said that the wish of the High Commissioner at the United Nations is that systems of justice, operators of them, become allies of indigenous peoples in trying to obtain justice. Ecuador concurs with this idea or vision of the High Commissioner, and during that meeting there were 3 conclusions arrived at. One, to make progress with laws that acknowledge indigenous justice and their authorities, and also make progress in the coordination between these systems of ordinary and indigenous justice systems. And another pivot of this same meeting another person said that ordinary right should be decolonized. This is a reality in Latin America that cannot be denied. Emphasis was also made in protecting people that defend human rights in the indigenous communities, and also to sanction people who threat or persecute indigenous people. So this is the context of the audience that we have here at present today. Michelle Navarro, attorney who's here from the Attorney General's office, will show us a vision of the state structure of this principle and how this has been sent down to all the different entities of government, the 5 different entities, and the Constitutional Court. Obviously, cases are making progress. Public policies and protections in them for indigenous peoples are also making progress. So Michelle will make this brief presentation, but I will refer to 2 points that have to do with very new products or new tools that this coordination can use for the coordination between indigenous and ordinary justice. And these are called guidelines for the application of intercultural issues. This is from 2022, and we can take from these procedural tools and things to implement. And it is a guide also and protocol, or in 2023, that stems from someone that was named by the representative, or rather the habeas corpus idea of the Constitutional Court. So the reaction of the state is to create these 2 documents that will be sent to us in a complete package so that the Inter-American Commission can have them. And these are the guidelines of cooperation between ordinary justice and indigenous justice, and the interjurisdictional one. This is from 2023, and also the protocol where this discussion lies in regarding guarantees jurisdictionally. Professor Navarro, please. Good afternoon to all representatives of civil society, commissioners. My name is Michelle Navarro, and I represent the Ecuadorian state about the progress and coordination of the principle of intercultures. When we speak of this principle, we have to go to the Constitution of 1998, where it was said that Ecuador is a pluricultural and multi-ethnic nation. But in the Constitution of 2008, this was said in more detail and what interculturality means. So my presentation here is on screen, So the next slide. Perfect. In Article 171 of the Constitution of Ecuador, we find that the authorities of the communities, peoples, and indigenous nations will exercise their own jurisdictional functions. Based on their ancestral practices, they will administer justice, and the state will guarantee that this is fulfilled. In the same manner, in Article 56 and 57 of the Constitution, where the collective rights of communities, people, and indigenous nations are stated. So it states that they can create, develop, and apply their own law. And this is something that is reflected in many jurisprudence and in all the functions of the state. In the next slide, here we see examples of how in Ecuadorian law we have in the penal code, the organic penal code that regulates the punitive actions of the state, it considers the judgment prohibition. So someone that's been judged in the indigenous justice cannot have double jeopardy by being judged again in ordinary justice or vice versa. This also acknowledges the multicultural principle and the cultural diversity that are related to different practices, habits, and cultural practices. So linked to this, it also regulates the procedural matters and says that all diligence and sentences that indigenous communities do act upon have to be translated into their own languages. And the organic law of jurisdictional guarantees and constitutional control makes clear that the Ecuadorian state has said that the protection between indigenous justice and ordinary justice has to be respected if it's done in the indigenous people. The next slide, we will see here that in all state functions, this intercultural principle is being emphasized. There are several bills of law that are going to the National Assembly right now, and these are speaking of the rights of indigenous communities. So intercultural education, practices, ancestral practices, and a specific one on the application, the execution of indigenous justice. This is already before the Assembly. Also from the executive branch, we have tried that this is guaranteed by the state, this intercultural aspect. And the different peoples and indigenous nations, the Ecuadorian state has created a secretariat or a department so that there is a register of all these nations and indigenous peoples with all their traditions and practices. In the same sense, for voting by the law that regulates participation in political movements also acknowledges this principle of intercultural and plurinationality that exists. By the same token, in social control and transparency within this function, we can see that by equality councils, there is a council of peoples and nations specifically, and their function is to supervise that all rights of citizens are respected, and is specifically for peoples and nations. And finally, we have the judiciary function, and during that judiciary, we have the Council of the Education for the government discipline of judges. And there are several guidelines there so that there is a harmonious interaction between ordinary justice and the indigenous justice. So In 2016, this guide for transversal principle of intercultural within the ordinary justice. So this was the first acknowledgement that these principles existed under the law. So there was the principle of pro-indigenous justice and equality and non-discrimination. So the Ecuadorian state, by way of this, reiterates that the protection and multipluralism and ethnic diversity that exists in our countries will not only be written in law, but in the practices of the state. So with this, I hand the floor back to Dr. Fonseca. Thank you very much, Michelle. We have very little time, so I think that we believe that it is important that this process of making this transversal and seeing this sort of pentagonal structure with all the function of the states, I don't think we need the slide anymore, but in it, within it, there is progress that has been made. But as Michelle has said, the most important part of all of this are practices. And there is a need for judicial culture. And if there is this encounter between ordinary justice and indigenous justice, this is being done day to day, every day. So the guideline mentioned for this principle, the intercultural principle, creates a very concrete landing of all these actions and functions. Two sections that we believe are important. We will also provide the Inter-American Commission this document. One, it would be all investigations. This is being done in both types of justice in two ways. The anthropological one, that is based on an intercultural interpretation of the facts of the case, the individual debate and collective debate and discussion of conflicts that exist, and the possibility of sociological research where you acknowledge that there is another culture there and the social interactions between these two systems. So then several functions or actions are done, and there are interpreters and not just translators. And this epistemologically is important. So it is not just contracts with translators, but with interpreters. And interpreters do more than translators. They interpret the cultural aspects and evidently of the experience of these indigenous people and those communities. So cultural interpretation, the guide says, cannot be limited to isolated cases as just a translator. So different from a translator, an interpreter knows the language of that community and also knows the expressions and idiomatic expressions of that culture. So they understand in a better manner what is being desired as their expression of what they want to say. So these different frictions that can exist between indigenous justice and ordinary justice can be solved in this manner by being interpreted. And this is a process that should be culturally balanced. And that process, it is not the same as a text and a written text. This version should be a dialogue based on the characteristics of administration of justice that is intercultural. And in this guide, what they're using are the guidelines of this habeas corpus operandi that was cited by the people that requested this hearing. That this process be a two-way street and aware of cultural differences, that there is coordination, and that the measures to be applied have cultural notions of due process. So all of this should lead to different discourse. There are enormous elements here, and there are inter-American standards within this, and they're methodological ones of the court. The case of Yotojin against Guatemala Guatemala, and Mexico through the protocol of the Supreme Court of Mexico regarding the protection of indigenous peoples. So this is a very important effort, and this is all we have to say, Mr. Chairman. Thank you very much for your important message. And for about 7 minutes, I welcome Jan Jarat, who is the representative for South America of the High Commissioner of the United Nations for Human Rights. Yes, Commissioner.
Representantes y de pueblos indígenas, amigos y amigas.
Friends, I am Jan Jarat, as the representative for the High Commissioner of Human Rights. I am here to provide the court information orally, informally, and without being under. I have not sworn myself in. The faculties of these indigenous peoples to maintain and reinforce their own systems of administration of justice are a component of their self-determination, self-government, access to justice, in virtue of international exercises and instruments, the Declaration of the United Nations of the Rights of Indigenous Peoples, and the Agreement 169 of the ILO, as well as the American Declaration of the Rights of Indigenous People. In the case of Ecuador, the Constitution acknowledges the exercise of this and the application of norms of justice that do not go against the Constitution or the international law. And we point out that this is to coordinate the two different systems of justice, ordinary and indigenous. It also establishes the obligation of the state to guarantee this indigenous jurisdiction that will be subject to the Constitution. In 2023, the High Commissioner, when he visited Ecuador, met with the indigenous movement as well as with the Constitutional Court and discussed with them this subject of indigenous justice and the coordination between both systems. And also our offices organized a regional dialogue on indigenous peoples and access to justice in Santiago, so that this could, with the participation of the judiciary and the people of Ecuador, and the Special Rapporteur of the United Nations spoke of the rights of, and Francisco Cari pointed out that justice can respond to the lack of judicial protection or justice protection for these people when sometimes it is denied as a result of racism or racial discrimination. In this dialogue, I will invite you to look at our webpage. It's all there, and also it was mentioned the lack of trust of the indigenous people towards ordinary justice due to the long history of impunity on sentencing. So it was and non-compliance with sentencing, and it was pointed out that this indigenous justice is less contentious than ordinary justice. They usually are efficacious and balanced, and they are a collective form of justice. So socially, they are legitimate and they promote knowledge, values, and principles that are community-driven. And they can also represent what happens in the ordinary justice regarding indigenous people. However, in the dialogue, other problems were also noted in countries such as Ecuador, even, who do acknowledge the indigenous justice at a constitutional level. So in this context, I'd like to mention several concerns that exist, along with the concerns pointed out by the previous Special Rapporteur, Victoria Antami-Corpuz, within the framework of her official visit to Ecuador in 2018. Firstly, that in practice and the interaction between systems is still limited, and that there is still discriminatory actions and attitudes and lack of knowledge of the contribution of these indigenous justice contributions to regular justice, to normal justice. So, in the administration of indigenous justice, there are things that are not pointed out in international rights or law or in the Constitution. Fourth, that human resources and financial resources are not being provided for this type of justice, which then delays harmonization of indigenous justice with the international human rights law and principles, and that there are cases of criminalization of indigenous authorities of indigenous justice, as it has been mentioned by the petitioners.
En este contexto,
Within that context, I would like to reiterate the call of Francisco Cariz, Special Rapporteur, and other members of the regional dialogue to value indigenous systems of justice. They are dynamic, diverse, and they can play an important role in equal justice for all. And this is very important in the present situation where indigenous people are facing challenges such as discrimination and including lack of access to ordinary justice because of a lack of sensitivity to this difference and the being evacuated or taken out of their lands or their lands being taken and other economic situations and attacks to those people who defend human rights. So without their having the access to mechanisms that protect them, they will be vulnerable. So these indigenous people have to maintain, develop, and reinforce their own systems of justice and fight against stereotypes with information programs and teachings, as well as anything that facilitates the acknowledgement of both systems and harmonizes them. And all these efforts should be provided so that they satisfy the needs of the communities, especially of women, young people, children, and people with disabilities. In the case of Ecuador, to guarantee the right to administration of justice of peoples and nations, in coordination with ordinary justice, will be a sure step in constituting this plurinational state as established in the Constitution, and can contribute to do away with those barriers that impede all this and access to justice. Thank you very much for your attention. Thank you very much to the United Nations, and we will now hand the floor to the rest of the table. Estuardo Ralón, the rapporteur for Ecuador. Thank you very much, Mr. Chair. I would like to first greet all representatives of the National Confederation, Indigenous Confederation of Ecuador, and the movement of Cotopaxi, and the representatives of the state, and the ambassador who is here today. So I would like to ask two questions of the government and then others of the representatives of the indigenous people. And for the state, for the government, my first question would be, have you identified any cases of criminalization of indigenous authorities concretely, since we have listened during the hearing that the representatives of the indigenous communities provided examples of this? So I'd like to get more specificity on this. And then to the representatives here, my question would be, what control mechanisms exist in any given situation, knowing, as you have said during the hearing, that there are constitutional limits and human rights limits? So if there is any failure or something that cannot be done, what control mechanisms exist to make someone responsible without criminalizing them? Commissioner Christopher Broken.
Good morning to everyone, and I'd like to echo my colleague, Commissioner Alon, in welcoming all the participants. In particular, is there a transmission?
Ahí está la
Disculpen, tenemos auriculares para la interpretación del comisionado Arif Pulkan. Confírmenos si...
We have earphones. Can you hear us in English? Can you hear us?
Thank you, Tanya. And my apologies. I hope you can hear me clearly. And yes, so I was simply welcoming you and greeting you. And I'd like to begin by thanking you, Mr. Representative from the Attorney General's Office, for your opening comments, in which you highlighted the role of the CIDH in promoting democratic institutionality and resolving conflicts in the region. And I took particular note of the commitment you expressed on behalf of the Ecuadorian state in achieving and going after this goal, which I find very encouraging and promising. In the same vein, I wish to echo some of the comments of the representative of the United Nations High Commissioner and acknowledge that at international law, certain rights of indigenous peoples have long been recognized, including, crucially, the right to self-determination. And as we all know, that right includes some measure of autonomy in formulating their own laws and operating systems of justice. Jurisprudence from the Inter-American system, our own system, recognizes self-determination as an aspect of the primacy of indigenous peoples in the region and a means of redressing historic injustices, such as the inequalities that resulted from colonialism and the loss of their lands. That recognition, I think it's important to state, is important to the survival of indigenous peoples, important to their cultural survival and the preservation of their unique worldviews and their identity. I think it's also important to acknowledge, as has been said today, that those principles are recognized in the Ecuadorian Constitution, which is actually a model for us. And so given this background and context, and in light of the violations that the communities have spoken about today, in particular the criminalization for the exercise of this right to indigenous justice, I'd be interested from the state if you could identify what particular obstacles you might have encountered to implementing this normative framework at the local level. And I'm wondering, in the interest of resolution and your own commitment to promoting these, democratic traditions, whether you think that training of local authorities as to this constitutional position might be useful, so that local agents are aware of this constitutional recognition, of the limits to the respective jurisdiction, and to coordinate. Now, this might well be going on, but I'd just like to know whether or not there is a sustained policy of training. And if so, why then, how then can we account for these slippages and the criminalization that we've been hearing about? And in light of the fact that there's been these allegations of criminalization, is there any accountability at the local level where those principles are not respected, in particular, since they are constitutional guarantees in Article 171? And to the representatives, I'm very curious about the 29 cases that you've mentioned, and if you could perhaps give me just a little detail about them. And what I'm interested in understanding, is there any sort of connecting factor to these cases, any kind of factually that are responsible for this criminalization? I think I heard from you that there is this stigmatization of indigenous communities, that the exercise of this right to indigenous justice is portrayed, or there's a narrative that it is terrorism. Could you explain that for me a little bit? Because understanding perhaps the causes of this criminalization, why state agents are moving in this way, might be one way during the dialogue of addressing the problem and removing it. So thank you very much.
Thank you very much. Buenos días.
Good morning once again. I'd like to refer to a very important matter that was mentioned by the representatives of civil society. They talked about the great work that the Constitutional Court has done in Ecuador. Ecuador has a great constitution from 2018, and it has this article that recognizes recognition according to the territories of the indigenous communities. And in other parts of the region, people are surprised because they always circumscribe these to political territories, municipalities, etc. And in Ecuador, this territorial recognition is excellent. And the Constitutional Court has also done other things that were mentioned here. But I want to ask a question, and I do confess that I miss sometimes the participation of the high courts and the delegations from the states. I miss it because this is a question that they could answer. Having these very robust judgments, these rulings, how is it that, as civil society was saying, you don't have this understanding, and there's that rejection of their jurisdiction? Why is this divorce, and sorry for the word, between the ordinary jurisdiction and there? Why isn't there a relationship? Because otherwise this whole conventional protection of rights that Ecuador has was not realized and has a very meager actual effect. And then I wanted to ask about Article 17.1 that's related to the territorial identification. What happens to ratione personae? So there's a recognition of these rights by the indigenous communities, and how would this self-determination work? And Mr. Fonseca Garces was saying something, and I thank you for mentioning this epistemological explanation about going from a translation into an interpretation, and I thank him for this. But I wanted to ask, is there any additional awareness building that we can do for those that are operating in the ordinary justice system, not just in terms of acknowledgement, but even in terms of empowerment of the citizens within the indigenous community? So those would be my questions. Now it's the Executive Secretary has the floor. Thank you very much. I want to extend my particular greetings to the delegation. Thank you for preparing this presentation. I know that there's a lot of work behind it, and to your presence. And thank you also to the illustrious delegation from the state, Ambassador Montalvo. It's a pleasure to have you here, and all the people from the mission with whom we work so closely. I think the commissioners have very clearly established the logic of that gap between what's in the regulations and what happens in reality. I'm very grateful for the comment by Mr. Jan Jarab, the representative from the UN, and the special rapporteur from the UN came to 5 conclusions along the same lines of what the commissioners have said. I'd like to ask the state, in light of this new administration, you have a new administration in the government. Do you foresee that institutionality will be strengthened, that there will be specific institutionality capable of increasing interaction between the state and indigenous justice procedures? Is this something that you have plans for in your project for this administration? Since it's a new government and new administration, it might be a good opportunity for this. And I'd like to hear also from the petitioners about the experiences you've had. You've told us about the lack of interaction with the state, indigenous justice processes. You've told us about a lack of cooperation among jurisdictions, but perhaps tell us about the consequences of that lack of interaction. What does it mean for you when you don't have that interaction? What is the specific result of this, a specific impact on people's lives? If you could give us 1 or 2 examples that, although we see it in the report, it's clearly established. I think it would be very important, since we also have this new representation. It would be great if we could hear it from you. Thank you very much. Thank you, Executive Secretary. We now give the floor once again to civil society and its representatives for up to 10 minutes for a response and for them to add whatever they feel is relevant. Good morning. I'm Mario Melo, advisor of the indigenous movement. I'd like to congratulate the Ecuadorian state on advances made regarding regulations, protocols, and guidelines on making ordinary and indigenous justice more compatible. However, I need to point out that 16 years have gone by since the Montecristi Constitution proclaimed the Ecuador a plurinational state, and 26 since 169 of the ILO is in effect in Ecuador. And these advances are just from last year, and they're the result of rulings by the Constitutional Court as a result of the efforts of civil society, the indigenous movements that has sued the state and has won. So I think there's a need for this progress to be more timely, more efficient, and especially to work on that implementation gap, so that daily justice reflects what's in the books. I'm Aristo Paza, president of the Indigenous Movement. I'd like to say to the High Commissioner that the ordinary judicial system in the country is not that good. They have not understood that there's interculturality, and they have not understood about indigenous jurisdiction. Through the judges of the country, we've tried to say that indigenous justice is voluntary, or that's what they try to say. No, it's the community, the will of the community, and it is a customary right that we have. I was listening a while ago about the consequences being generated by the administration of indigenous justice and criminalization and judicialization. One of the main impacts is that at this point, many companions, many colleagues that are leaders, community leaders, have been accused, have been fined, have been imprisoned, and there's a very deep social conflict, and there's a history. And very few people, for these reasons, want to be leaders of the community, because there's fear that indigenous justice administration will cause them to be criminalized and to be investigated by the authorities. There's an absolute fear, and many communities are simply don't have representation by leaders from the communities. So this is a problem for our community life, and I consider that it's very important to point this out. Also to say that where a jurisdiction is denied, they say that we are not capable of doing it, but I want to reiterate that other criminal actions are already being dealt with are being investigated. So that would be a double jeopardy. Lenin Zarzosa, legal advisor of CONAIE. Regarding the 29 cases and the question about facts and direct consequences, I'd like to talk about the following. We've seen in the cases that what happens is that the law enforcement works ex officio on their own, where they report to the National Prosecutor's Office, and they open up their own investigations. And the community authorities enter into the system, the community rulings, and this means that those investigations should be filed, because these are cases that are clearly under indigenous jurisdiction. But this is not happening. Those investigations by the state continue. And then this leads to criminalization processes. And the impact of this are obviously legal expenses that communities need to deal with. And there's excessive use of their criminal authority. And at the same time, as the president of the Cotopaxi indigenous movement mentioned, social pressure and that persuasive force that is a characteristic of criminal law, where members of indigenous communities are overwhelmed by this, and they are afraid to exercise their rights as community authorities. So this is a comprehensive issue. And in the report that we submitted, this is dealt with in greater detail. And we say that there are criminal proceedings against approximately 100 community leaders. So we call on the Ecuadorian state to resolve these cases rapidly. We have certain instruments, but the mechanisms do not lead to immediate results. They are still under discussion. The Ecuadorian state, I'm Leonidas Isa, president of CONAIE. The Ecuadorian state has presented various illegal constitutional instruments. The Confederation of Indigenous Nationalities, CONAIE, has even signed an agreement with the Council of the Judiciary in order to move forward with the application, the respect, coordination, and cooperation. However, in practice, not much happens. In fact, what we've seen that I'm very concerned about, not just related to indigenous justice, but also to our 21 collective rights, self-determination, organization of community guards, etc. What I see is that stigmatization and criminalization has been normalized. And when it's coming from a segment of the citizenry that are talking about terrorism and vandalism, well, that's fine. But when it's anything having to do with the indigenous struggle, then the National Attorney's Office immediately opens up an investigation. And what happens is that they're looking from a colonial perspective. It's like it's not important to them. They're not interested. Or we're trying to justify what we do, our transcendence as a part of a plurinational state. And what are some of the impacts that we've seen? Well, this is a constitutional mechanism. The Constitutional Court needs to review the indigenous judgment by the petition of one of the parties. So then an investigation is opened up. But what is happening now? The prosecutor's office, in this case, acts ex officio, so outside of the framework of this control. So a judgment that has been issued and we have a resolution by the Constitutional Court. It's only when everything is going wrong, that's when they try to fix it. And there's the question from the commissioner. Well, there's a mixing up of what we do with terrorism. Why? Because each administration in the government, in the Lasso administration, for example, when we try to exercise our collective right with previous consultation, and we have problems in indigenous territories because of mining and oil exploitation, they don't ask us. They talk about environmental consultations, but when the community guards with their own ruling in the indigenous community try to make their rights respected, then they call them terrorism. And then in 107, again, I reiterate, it says that we have ancestral weapons when we've never had those. It's easy to make that mistake. And they say that those ancestral weapons need to be authorized by the Joint Command of the Armed Forces. It's ridiculous. And now in Decree 111 by President Novoa on the armed conflict, this decree determines that among the new threats to security, and this is important for all to hear, and the monopoly of forces, there's also tribal groups. And what does this mean? If we go to the concept of tribal groups, we're talking about original communities. Are they not trying to confuse these or link the struggle of indigenous peoples for their land and link that to terrorist acts perpetrated by criminal groups in Ecuador? These are matters that we have to deal with on a daily basis. There's been a discussion lately, and we are struggling so that our indigenous territories are not attacked by mining companies without previous consultation with us. And that's not what we're talking about today. But we've said that the 21 collective rights, indigenous justice, education, territory, all those rights need to be looked at as a whole. We cannot separate them. Thank you. Thank you very much. The state has 10 minutes for its intervention. Thank you, Alonso Fonseca, once again. We'll try to answer the questions and the concerns of the commissioners in order. Commissioner Ralón was asking whether we've identified cases of criminalization, and we'll ask the representatives and the petitioners in the hearing to submit to us information about these 29 cases because we need to work on them. There are some references to them in the document from December 3rd, 2023, but there are other matters that are not mentioned that we don't see in this document. So it's important to receive this information. And as the Attorney General's office of the state, we need to look at this. Also, the Council of the Judiciary, as these are the entities that have the competency and the jurisdiction on this. And Commissioner Volkan was asking some complex but important questions, and perhaps we don't have enough time to fully answer. So we'll also submit a response in writing. But the commissioner was saying that we are close to achieving certain goals, going from a moment where we acknowledge rights to where we actually implement them, going from a time when in a regulatory sphere we've had some successes. We need to translate that into more practical implementation processes, and that's the most difficult part. You were talking about some of the key issues of this discussion: autonomy, the matter of equality of the justice systems, the discussion on self-determination. These are discussions that are picked up within the principles that we've established. But of course, in the world of day-to-day procedural cases in Ecuador, especially in the mountainous area, there can be some complexities. Before coming to this hearing, we held several meetings with the Council of the Judiciary, and they were explaining to us what some of the issues were in implementation, some related to ignorance, not just by the operators of justice, but also within the local areas regarding the indigenous justice system. So we need to identify the problems first. The first one is communication. A second problem is the challenge of institutionalization of a procedure that, as the colleagues or representatives of civil society were saying regarding the declining of competence or jurisdiction. And there's a very simple process. Upon the petition of the indigenous authority, this jurisdiction declination process is activated. The judge needs to know about this. Then there is a period of 3 days during which it is revised, and there needs to be a sworn statement by the community that this is a decision of their community. And then the judge has the ability to put away, to file away, and remit the case to indigenous justice. So this is Article 3, 4, 5. But sometimes, in some cases, it's not clear to some of the operators within the judicial system, especially in the mountainous areas of Ecuador. There are certain complexities, but so we need to have better knowledge about the whole procedure. In the questions also, there was a concern regarding having greater clarity, on what happens with matters such as transferring certain concerns, as the chair and vice chair were saying. Why aren't the representatives of the Constitutional Court here? What is happening with that process, where we are going into a phase of actually empowering indigenous authorities? I think especially in the case of the guidelines, and we're going to submit that along with all the other information that we've presented. This guide includes a mechanism for relating and communicating with indigenous justice through each one of the provincial directors of the Council of the Judiciary. So they are the points of contact through which we learn about problems happening in the indigenous territories. And that's where the rubber meets the road, regarding coordination on the one hand and a process of complementarity that can also exist. We need to look at that possibility as well. In ordinary justice, there's a lot that we need to learn about indigenous justice mechanisms, even from the perspective of efficiency. The guide establishes, for example, that when there is a conflict between the jurisdiction of peace, and we have important history here, indigenous justice will prevail. The guide says this. So we've worked on this already. And in these local areas, sometimes the challenge for the Council of the Judiciary and the provincial directors is coordination. Sometimes when there's due diligence that needs to be done on site to determine what the conflicts are in the territories, we need to have a facilitator to provide a methodology for this dialogue to take place. Dialogue continues to be a basic technical necessity because we don't know each other well. There needs to be a process of deepening understanding and understanding why many of decisions of indigenous justice or their own reflections and thoughts are not written down. So it's a Western epistemological difficulty where we expect everything to be written down, but many decisions are made in an oral context. So it's a lack of understanding of our Andean culture, which through westernization we've come to expect that everything will be in writing. So here we have a significant challenge, and keeping a limited time in mind, I'm going to what the executive secretary was saying. She was talking about what possibilities exist now that there's a new administration. Of course, we are going to consult on this. But I would say that there are, in fact, enormous opportunities in Ecuador right at this juncture. There's a sort of national agreement in terms of the need to fight insecurity. And the dialogue with indigenous groups, of course, is fundamental for this. I want to be very clear about this. Thank you very much, Mr. Chair. Very good. We are reaching the end of our hearing. I want to thank you all for participating in this hearing this morning. It's very useful for the Commission to understand better, to gain more information in order to do its work in favor of your rights, and also for establishing communication between the various parties. That's very important for us as well. Thank you very much and have a good day.
hearing number 9 of the 189th period of sessions, and the title of this hearing is Impact of Uranium Mining on the Rights of Indigenous Peoples in the United States. I want to acknowledge representatives of civil society as well as Ambassador Mora and representatives of the state. This morning we have our usual methodology of the hearing. We will allocate the first 20 minutes to representatives of civil society to make their presentation. The state has equal time, 20 minutes. We will have, the commission has 20 minutes to make comments or ask questions, and then we go back to civil society for another 12 minutes and to the state for another 12 minutes, and that's how our time is organized. Before I begin the hearing, I would just like to recall and celebrate that the Inter-American Commission on Human Rights is commemorating 65 years of work committed to the defense and promotion of human rights in the Americas and the Caribbean. Since 1959, when we were established, thousands of individuals and groups and peoples have turned to the Commission seeking protection, justice, and reparations, and many states have also turned to the Commission for technical advice on compliance with international human rights standards. So we celebrate 65 years of history. We've had more than 100 on-site visits. The statistics are impressive. More than 1,000 precautionary measures have been granted, over 750 merit reports prepared, 220 friendly settlements, and we hope to move more in that direction, Executive Secretary, and 377 cases have been sent to the court. All of this with the victims as a central focus of our work and our priority, and of course, working with states to ensure accountability for compliance with their international and regional obligations. I also want to say for those who are joining us online, on the point of accessibility, to ensure that this hearing is inclusive, we ask all participants to begin your presentation by stating your name, your position, and the organization or institution you represent. And every time you take the floor, please repeat that, at least your name, so that the visually impaired can identify who is speaking, those who are online. Likewise, we remind you that these audiences also have Zoom subtitles available as well as interpretation. So everyone who's online can activate them directly from your own computer and choose the display size. For those who want to follow us, not on Zoom, but otherwise, we are accessible on the Inter-American Human Rights YouTube channel, as well as live stream on Facebook, and I also understand live stream on Instagram, not Instagram, so just Facebook and YouTube. So with that, I would like to turn to representatives of civil society for your presentation. You will see that there is a clock on the screen, which you can use that as a guide to making sure that you've completed your presentation in the time allocated to you. Over to you.
Thank you, Madam President. Good morning, Madam President and members of the Commission. My name is Eric Jantz. I'm the Legal Director at the New Mexico Environmental Law Center. The testimony you'll hear this morning will bring to light a long overlooked issue, how the U.S. government has jeopardized the inherent rights to life, health, culture, environment, and water of hundreds of indigenous communities across the country in pursuit of a single mineral, uranium. For decades, federal agencies have understood that unremediated and inadequately remediated uranium mines and mills pose a public health danger to those living nearby. For even longer, federal agencies have known that mine and mill waste have contaminated vast areas of land and huge amounts of water. Federal agencies have ignored or suppressed information about the dangers of uranium development. They've dragged their feet on uranium waste cleanup from historic mining and milling in Native communities, while at the same time promoting and subsidizing new uranium production in those communities. The U.S. has rarely, if ever, secured tribal consent for uranium production on and near tribal lands. The cost of the government's lopsided policies have disproportionately fallen on Native communities. Edith Hood and Teresita Kiana from the Navajo Nation, Anne from Nebadback from the Ute Mountain Ute Tribe, Carletta Talusi from the Havasupai Tribe, Big Win Carpenter from the Northern Arapaho Nation, and Tanya Stans from the Oglala Lakota tribe of the Great Sioux Nation will testify about how uranium policies have affected their communities. We have supplemented their testimony with written materials. In our request for this hearing, we identified several recommendations, some of which we are reiterating here today. We asked the Commission to make to the United States. First, we call on the United States to place a moratorium on all new uranium mining and processing on indigenous lands or near culturally important sites until it has remediated all legacy waste and implemented laws governing uranium development that are consistent with its human rights obligations. We also call on the United States to begin phasing out ongoing uranium mining and processing in indigenous communities. The only exception to this moratorium would be when an indigenous nation has given its free, prior, and informed consent to develop mineral resources within its jurisdiction. Free, prior, and informed consent should also and especially include the right to say no. Finally, during a moratorium, federal agencies responsible for regulating uranium production and remediation should review and change as necessary their policies and regulations to be consistent with the United States human rights obligations. Thank you, and we look forward to any questions you may have.
Yate Shay Edith Hooten Shea. I am from the Redwater Pond Road. Nahastashama is the name we give Mother Earth in our prayers. She provides all our basic needs: air, water, soil, light, and more importantly, it is our shelter. As the Net people, we are tied to the land in our daily lives. Our concept of hojon is constant in our lives. It means to live in balance, beauty, and harmony. When this balance is disturbed, our way of life, our health, our well-being all suffer. Where I'm from, we grew up with names of our communities such as Hizdike, or Hachitizai, are all in Navajo geographic terms. Our community is next to the #1 Superfund site on Navajo Nation, the Northeast Church Rock Mine. The #3 site is the Corvera Church Rock 1 mine, which I can see from my kitchen window. It is still yet to be cleaned up to reduce the risk of exposure. Around the corner is the place of the 1979 Church Rock uranium tailings spill, the largest spill of radioactive wastes in U.S. history. Through the years, after the mining left, we asked to get it cleaned up, but to deaf ears. Our community people participated in a cleanup pollution sampling in 2003 that was being done by the Church Rock Uranium Monitoring Project. The findings from that project finally got the Navajo Nation EPA and the U.S. EPA's attention. But as it is taking a lot of time to do a cleanup. Growing up in the community, I remember riding horses and grazing the livestock. When the mines came, our community was forever changed. People began to leave after we discovered contamination in the community because we were afraid for the health of the children and then our own. Only 2 families of the original 11 families still live in the community because of the supposed pending cleanup. We need to be in a safe, secure environment. It is our human right. Going back into history, the government established uranium mines in isolated areas with language barriers, no understanding or translation of what uranium is or what radiation is. How do you explain what you can't see, touch, or smell? The government was aware of the risk and the dangers, but failed and neglected to inform our people. As it is, the federal government puts its indigenous people at risk, never returning to check on the people and the land. There was no respect for people living on these lands and certainly no respect for Mother Earth. Thank you.
Good
morning. My name is Teresita Kiana from the Redwater Pond Road community on Navajo Nation. Thank you for granting us this hearing so that our community may finally get the environmental justice that we fought so hard for. I fight for my community, my family, and my children's future. I was raised by my paternal grandmother, the late Catherine Duncan, who worked for the Kermagee mines and later passed away from pulmonary fibrosis caused by her uranium exposure. She taught me all that she could of our language, our traditional values, and our culture. The cultural teachings I know from her are just a tip of the iceberg of our long-standing knowledge our Navajo people have and as first inhabitants of this land. My aunts and my uncles continue to teach me these values, but a lot of this knowledge has been lost due to the extractive uranium industry. After prolonged exposure to uranium in the home I grew up in, which caused me and my family significant health problems such as cancers, autoimmune diseases, skin issues, liver and kidney diseases, and even learning delays in infants and toddlers, I was displaced off the reservation into Gallup, New Mexico. I knew the move would provide my children with the safest environment free from uranium exposure, but when you move off of your tribal lands, your ability to practice your language and your culture becomes more and more challenging. We stay connected with family and regularly engage in voluntary mutual aid work to support our community and elders in the Redwater Pond Road, but continues to be a challenge for my children to speak their language and practice their traditions the way that we would have had if we could safely stayed on our homelands. The uranium mining industry has not only stripped the land of its natural resources, but also poisoned our groundwater and has left radioactive material in open mines in our community. Extractive mining and the United States government neglect of its responsibility to clean up these mines has harmed the land, poisoned our family and communities, and continues to cause harm by forcing us to relocate outside of our tribal communities and lose touch with our language and our culture. We want our voices to be heard and understood. Our community and people deserve justice not only from the extractive industry, but from the government entities that were involved in the decision-making of mining and milling these lands. Our children's rights to a clean environment have already been affected. Our children's freedom to practice their culture has been impacted before they were born. Thank you for the attention on this important matter.
Mike, my name is Anthony Badback from the White Mesa Concern Group. I'm a tribal descendant of the Yuma and Ute tribe. Yolanda Badback is my mother. I was born in White Mesa, Utah, and my people have lived on or near the reservation for as long as I can remember. We are the caretakers of this land and the water beneath it. Just a few miles from my home sits the last operating conventional uranium mill in the U.S., also known as Energy Fuels White Mesa Mill. We feel the mill has contaminated groundwater, plants, birds, and wildlife, and that it pollutes the air with radiation. Our ancestors' remains were desecrated to build the mill and continue to be buried radioactive waste near them, which impacts us spiritually. Sometimes when the mill is running, it smells like chemicals near my house. Our young ones are starting to get asthma, and nobody knows why. They never had asthma before. We are concerned about pollution in our well water. Most of us don't drink our tap water. We purchase bottles of water. The water underneath the mill is becoming more and more polluted and is moving towards our community. The acidity of the water is increasing and heavy metals are rising. We used to drink the spring water for our ceremonial purposes. We don't do that anymore. We used to hunt for animals near our homes. We used to gather plants for medicine and for baskets and to eat. We don't do that anymore as well. Radioactive waste and contamination in the lands of the Cherokee, Spokane, Muskogee, and many other nations, including international waste from Japan and Estonia, has been shipped to the mill. More waste left behind from the U.S. government could not come, or U.S. waste left behind from the U.S. government is coming in soon. They put tribes against tribes, and we don't support that. It's no longer just a uranium mill, it's now acting as a low-level radioactive waste repository, because now they're accepting various waste streams. The state of Utah regulates the mill, and they keep relaxing their standards, so the mill stays open. It's hard to live close to the uranium mill. We want to be free from the fear of getting cancer. We want to spend time outside without smelling chemicals. We want to use spring water for ceremonies without fear. We want to gather herbs and hunt without worrying whether the herbs are safe to use and whether the meat is safe to eat. We're concerned about the health of our young ones and our elderly and our youth community. We want the mill to shut down and properly be cleaned up. We want the mill and its contamination to be moved where it can't hurt any living things. Doyak, thank you for the opportunity to support my truths about how uranium has affected the White Mesa community. Please help us. We're waiting and wanting justice.
My name is Carletta Talusi. I'm a member of the Havasupai tribe. Havasupai means people of the blue-green waters. I am here on behalf of my tribe to provide testimony on the current mining activities occurring on the rims of our canyon home. And it's going to contaminate our main water source, Havasu Creek. The watershed and the sources of Havasu Creek are located on federal public lands around our reservation. An active uranium mine is also next to our sacred mountain, Red Butte, Weekadwisa, my tribe's creation stories. We have been against uranium mining for decades because of the known risks to air and water, land and people. The federal mining law of the 1872 still allows international mining companies to come onto federal lands, such as Pinyon Plain Mine, a Canadian-owned business currently conducting mining operations near Red Butte and causing environmental contamination. Uranium mining in the Southwest has scarred and left horrifying legacy of death in our communities. Thousands of abandoned uranium mines on federal and tribal lands have not been cleaned up. Large open pit uranium mines are still highly toxic and not mitigated. Nearby citizens have died of cancer. Uranium will continue to poison the Grand Canyon, including the aquifers that feed into the Colorado River. In 2017, the mining operations pierced an aquifer, causing 9 gallons of water per minute to leak into the mine shaft at Pinyon Plain Mine. In 2018, 96 million gallons of contaminated water spilled into the shaft. They stored the contaminated water on site. The mining company sprayed the contaminated water into the air to speed evaporation. In 2017, the Arizona Department of Water Resources found the mining company violated state law by trucking this water, considered waste material, for disposal out of state. The mining company has been cited with 16 violations by the Mine Safety and Health Administration. Recent scientific studies show that aquifers around the Grand Canyon are connected, and that the contaminants from uranium mining are likely to make their way to the deep aquifers that feed Havasu Springs. The mine closure is the only way to avoid this risk. This is a serious, urgent case. This is an active uranium mine at the Grand Canyon at the headwaters of Havasu Creek. We respectfully request that you urge the United States to change the 1872 mining law to prevent irreparable harm to the Grand Canyon and the Havasupai tribe's sacred waters. We respectfully request the Commission to present our case to the Inter-American Court to seek an order requiring the adoption of provisional measures to prevent irreparable harm from uranium mining to the Havasupai tribe's waters and sacred sites. Pinyon Plain Mine cannot be allowed to proceed. The Havasupai tribe is in front of the front lines of uranium mining contamination. Hangu.
My name is Bigwin Carpenter. I'm a Northern Arapaho tribal member. Fort Laramie Treaty lands across the Plains and Rockies bear the impacts of nuclear industry. In Arapaho, Wyoming, uranium mining and processing poisons the very ground we call home, leaving lasting impacts on our sacred sites, water, and future generations. As climate concerns rise, so do the proposals for nuclear energy, and the threat continues to jeopardize our collective well-being. Yet its proponents often silence the voices who have suffered and are harmed by its lasting impacts. They have rebranded nuclear as green, but the damage that it's done to our homelands and communities is far from green. Our communities and our lands have endured enough. We demand environmental justice. We need your support to hold accountable those who exploit our resources and oppose projects that harm our people and our homelands. Together, let's ensure a future where our voices are heard, our sacred lands are protected, and a truly sustainable future is found, and a solution to the climate crisis is found. Ho ho.
Hello, my name is Tokyagluhuniwi, aka Tanya Stans. I'm from the Pte Oyate who submerged from the caves of the Black Hills. I am a full-blooded Oglala Lakota woman from Oglala, South Dakota on the Pine Ridge Indian Reservation. I have spent my lifetime traveling within our treaty territory and to sacred sites to practice and use ceremonies as our way of healing. I was raised the Pine Ridge Indian Reservation and Rosebud Reservation share the White River Group aquifer system with Kamiko Crow Butte in situ leach aquifer uranium mine. We are sitting on top of the aquifer system that they're mining. They are proposing to set up another mine south of Crawford called Marsland. We may be the poorest county in the country, but we are rich with our cultural and our spiritual practices. People come from all over the world to share our connection we have with the land, the water, and the silent relatives. The increase of uranium also increases the heat in these ceremonial practices. Increasing the heat makes it more contaminated. This is our church. This is how we heal. Acid leach uranium is one of the, we do not have any end in sight. The answer isn't to open more ISL in situ leach uranium mines. We suffer from high levels of radiation and uranium contamination when we go into ceremony because of the simple fact that the heat is increased. So inside of those lodges, we are sitting with the increase of contamination in those lodges. We also sit on the ground where the radiation seeps under the ground, and we camp and we do our ceremonial practices on the grounds of these uranium mines. The biggest thing that I want to talk about is that the western tribes of South Dakota receive piped-in water from the Missouri River. This is supposed to save us because of our uranium contamination, when in fact, we have no filters off our groundwater, and this pipeline water that's coming in off Missouri River is bringing in all the Wyoming ISL uranium mines into our faucets. So we don't have filters to filter that out. And when we go into ceremony, we use that same water, put it in the lodges that increase the heat. So we are suffering at impacts that most all Americans do not receive. I ask that you take a look at that and that become part of the surveying process of opening up uranium mines. That is never on our grassroots communities to present that.
I'm so sorry, but your time is up.
Okay, thank you.
Thank you very much. You will have another time to speak, I think, a few more minutes in the second round. I turn over Ambassador Moore to the representatives of the state.
Thank you and good morning. Distinguished commissioners, secretary of staff, representatives of the organization who requested this hearing, and to all of today's speakers and attendees. My name is Francisco Mora, and I have the honor of joining you here in my capacity as U.S. Ambassador to the Organization of American States. This hearing gives us the chance to hear directly from those who have raised concerns with the Commission about issues pertaining to the United States. Thank you for being here and for this opportunity. At the U.S. mission to the OAS, one of our key roles is to foster engagement between our partner agencies and the inter-American human rights system. I am pleased to note that in recent years, the United States has been able to bring appropriate representatives from across our government to speak at hearings and working meetings. To this end, we welcome here today our colleagues from the Department of Interior, the U.S. Environmental Protection Agency, and the U.S. Nuclear Regulatory Commission, who will share with you the many ways that our government is addressing concerns related to uranium mining. Bureaus in the Department of State have ongoing engagements with tribal nation leaders related to a wide range of bilateral, regional, and multilateral issues. These include transboundary matters such as mining, environment, water, fisheries, and health. We value this continued involvement with tribal nations. Let me now then turn over to the Department of Interior's Assistant Secretary of Indian Affairs, Brian Newland, and thank you very much.
Thank you, Ambassador. Ani Buju Nogijigat, Yate, How, Maiku, Buenos Dias. Good morning, Commissioners. My name is Brian Newland. I am Ojibwe Anishinaabe from the Bay Mills Indian Community, which is located in northern Michigan. And I presently have the privilege of serving as the Assistant Secretary for Indian Affairs at the United States Department of the Interior. And I'm grateful for the opportunity to speak and testify today on behalf of the United States. As Assistant Secretary for Indian Affairs, I serve as a leader for the United States trust and political relationship with tribal nations. The Department of the Interior is at the forefront of reinforcing tribal consultation and consensus and facilitating tribal input into policy development and program implementation. It is fundamental to our belief that honoring our relationships with tribes and upholding our trust and treaty responsibilities are critical to achieving our mission. Tribal nations have played an instrumental role in advancing the national security of the United States as well as global safety. As you've heard and as we understand, these contributions include the period during World War II and have included the mining and processing of heavy metals like uranium for nuclear energy and testing of uranium on or near tribal lands. And we know this is especially true for tribal nations like the Navajo Nation, the Western Shoshone, the Pueblos of New Mexico, and many other tribes. Today, the process that we use to engage with tribal nations looks much different than the process the federal government used in the past. For example, on January 26th, 2021, President Biden issued a presidential memorandum reaffirming the Executive Order 13175 on consultation and coordination with tribal nations. The duty and responsibility to consult with tribes is not limited to the Department of the Interior, but rather extends to all federal agencies. Federal agencies are required to have a consultation policy to lead them in their engagement with tribal nations and inform their decision-making. In March of 2021, the Department of the Interior began engagement with tribal leaders on ways to improve our consultation process, as well as to identify best practices and strengthen our relationships with tribal governments. Through these consultations, the Department was able to identify and define the hallmarks of proper consultation with tribes. These hallmarks include providing sufficient notice to tribes of the topics to be discussed at consultation and enough details that tribal leaders and their representatives can fully and meaningfully engage with the Department. It is also critical for those Department officials who will ultimately be making a specific decision to personally discuss the issues involved with tribal leadership. It is likewise critical for the department to formally respond to tribal concerns and comments and identify how those comments and concerns were incorporated into our final decisions. It is our policy that consultation is required when any action we are proposing would have a substantial direct effect on one or more tribes, where it would impact the government-to-government relationship with the tribe, or where it would impact the distribution of power and responsibilities between the federal government and tribes. In many instances, we must conduct outreach to tribes to determine whether any of these criteria have been triggered. While this level of engagement may be time-consuming, in the long run, it ensures that the department is meeting its trust and treaty obligations and making fully informed decisions. The Department of the Interior is also leading a new interagency working group on reforming hard rock mining laws, regulations, and permitting policies in the United States which govern uranium mining. Government-to-government consultation with tribal nations has been a feature of this work. The administration released in the fall of 2023 the Mining Reform Interagency Working Group report with several recommendations for promoting and protecting the interests of tribal nations and tribal citizens. Just as during World War II and other times in the past, we know that tribal nations and American Indian and Alaska Native people will continue to play an important role in the United States national security, as well as our engagement with foreign nations. The United States will continue our work to elevate our relationship with tribal nations as we do so. I want to say, miigwech, thank you again for the chance to connect with you today and for the important mission of the Inter-American Commission on Human Rights.
Good morning. My name is John Lubinsky, and I serve as the Director of the Office of Nuclear Material Safety and Safeguards at the United States Nuclear Regulatory Commission, or NRC. I am pleased to have the opportunity to speak with you today. The NRC is an independent safety regulator. Our mission is to protect people and the environment. Regarding our roles and responsibilities related to the focus of this hearing, it is important to note that the NRC regulates processing of uranium ore called uranium milling. The NRC does not regulate uranium mining, nor the waste from uranium mining. One of the functions of my office is to provide regulatory oversight of uranium milling facilities. This includes both facilities that are operating as well as those in decommissioning. The NRC does not propose, site, or operate uranium recovery facilities. They are developed by private entities that must receive NRC approval along with the consent of other state, local, and federal oversight authorities. The NRC's role is to determine if such proposals meets the applicable requirements by conducting thorough safety and environmental reviews. During our process for reviewing license applications, we consult with interested tribal nations and offer an opportunity for hearings on our actions. The NRC is also part of a multi-agency effort focused on the legacy of uranium contamination on the Navajo Nation, including remediating abandoned mine sites and former uranium milling sites. The NRC respects the sovereign rights of federally recognized tribes in the development and implementation of agency policies and actions that have implications for tribal nations. The NRC's tribal policy statement provides principles to guide the agency's government-to-government interactions with federally recognized tribes. The policy statement also underscores the NRC's commitment to conducting outreach to tribes and engaging in timely consultation, and to coordinate with other federal agencies. In 2022, the NRC performed a systematic assessment of how we approach environmental justice in our programs, policies, and activities. The review included extensive outreach efforts to stakeholders, including environmental justice communities and tribal nations, other federal agencies, nuclear safety organizations, and the public at large. We found that our approach to environmental justice in our programs, policies, and activities has worked well, and the assessment identified opportunities for programmatic and policy enhancements as we move forward. Turning to our specific role, the NRC has a well-established program for regulatory oversight of uranium recovery facilities. Through decades of rulemaking, licensing, and oversight experience, the NRC has built a program of robust requirements for construction, operation, decontamination, decommissioning, reclamation, and groundwater protection. These requirements ensure safety and protection of public health and the environment. NRC regulations establish technical, financial, and long-term site management criteria for these activities. The NRC can assign certain regulatory authorities to certain of its regulatory authorities to individual states within the United States. We refer to these as agreement states. And we ensure that they demonstrate adequate and compatible programs to license and regulate some types of nuclear materials and facilities, including uranium recovery facilities. Most uranium recovery projects in the United States are in agreement states, and the NRC ensures these states maintain adequate and compatible programs through comprehensive periodic program reviews. The NRC's licensing process for uranium recovery activities includes both a safety and an environmental review conducted by our technical experts. The NRC staff documents its safety findings in a comprehensive evaluation to determine whether the proposal meets applicable requirements. Our environmental review is usually documented in an environmental impact statement prepared pursuant to the National Environmental Policy Act, or NEPA, and it evaluates and documents the potential environmental impacts of the proposed action. This review includes an assessment of cultural and historic sites in accordance with the National Historic Preservation Act, as well as an assessment of potential impacts to threatened and endangered species in accordance with the Endangered Species Act. To start the NEPA process, we have scoping, which is an opportunity to hear from the community and the public at large on what the NRC should consider as part of its environmental review. When we prepare a draft environmental impact statement, it provides our preliminary recommendations on the significance of the environmental impacts. We also issue the draft document for public comment and evaluate all the comments received and include them in our final environmental impact statement. In addition to its safety and environmental reviews and associated outreach, the NRC has an internal adjudicatory process. Through this trial-like process, independent judges of the Atomic Safety and Licensing Board panel hear and decide on concerns of individuals and entities that are directly affected by NRC licensing and enforcement actions. Participants in hearings have included individuals, citizens groups, private businesses, state and local governments, tribal members, and tribal nations. These three elements, the safety review, environmental review, including outreach and hearing process, are the foundation of NRC's review and engagement for uranium recovery proposals under its consideration. These processes provide robust opportunities for public and tribal engagement. I would like to thank the Commission for the opportunity to speak before you today about the NRC's role for ensuring safety. While the NRC does not regulate uranium mining, we have and continue to work with EPA, U.S. states, and others in addressing legacy mine contamination. The NRC is excited to continue to work with the Navajo, Ute Mountain Ute, Oglala Sioux, and other tribes and stakeholders moving forward. Thank you.
Good morning, Madam President, distinguished commissioners, and all participants and attendees of today's thematic hearing before the Inter-American Commission on Human Rights. My name is Clifford Villa, and I have the honor today of joining you on behalf of the United States Environmental Protection Agency. As Deputy Assistant Administrator, I currently serve as a senior political official for the EPA Office of Land and Emergency Management. My office provides leadership and guidance on EPA policies and programs, including the cleanup and restoration of contaminated lands in the United States. This work includes addressing the impacts of uranium mining on indigenous peoples, one subject of today's thematic hearing. While serving today as political leadership for the EPA, I also approach the subjects of today's hearing from multiple perspectives, including as a native of the state of New Mexico. New Mexico is one of the states most impacted by uranium mining in this country, and also a place with unique geography, history, and multicultural communities. I also come as a scholar teaching and writing in the areas of constitutional law, and environmental justice. Commitment to environmental justice and to working with tribes and indigenous peoples form long-standing hallmarks of the EPA's work and now express priorities of the Biden administration. In 1984, the EPA issued a policy for the administration of environmental programs on Indian reservations. The 1984 Indian policy recognized the sovereignty of tribal governments and established a system of government-to-government relationships that the EPA continues to reaffirm over time. In 1994, President Clinton signed Executive Order 12898, which among other things directed each federal agency to make achieving environmental justice part of its mission. The same executive order also explicitly provided that each federal agency responsibility set forth under this order shall apply equally to Native American programs. In 2014, after significant engagement with community advocates, the EPA issued a policy on environmental justice for working with federally recognized tribes and indigenous peoples, clarifying its mission to protect the health and environment of all indigenous peoples in the United States. In 2023, President Biden signed Executive Order 14096, which builds upon EPA's long-established definition of environmental justice, among other things by emphasizing the importance of considering cultural and subsistence practices. Executive Order 14096 also directs federal agencies to consider measures to address disproportionate impacts to human health and the environment from all federal activities, and including consideration of cumulative impacts and other burdens, including climate change. Without question, the legacy of uranium mining and milling activities in the United States raises serious concerns for environmental justice, with disproportionate effects on tribal lands and indigenous peoples. Given the priority that the EPA and Biden administration places on environmental justice, EPA headquarters and regional leadership and staff have engaged with tribal governments and indigenous peoples to understand and attempt to address their concerns. To maintain continual engagement with tribal governments and members of the Navajo Nation in particular, we also recently established a field office in Flagstaff, Arizona. EPA's work to address mining contamination is supported principally by one federal statute, the Comprehensive Environmental Response, Compensation, and Liability Act, known commonly as Superfund. Superfund implementation is guided by the principle that responsible parties, as defined by the statute, should be required to pay for all costs of cleanup. Otherwise, the EPA may pay for cleanup directly, drawing upon a Superfund maintained historically by federal appropriations, industrial taxes, and cost recoveries. Within and around the Navajo Nation, the U.S. EPA, in partnership with the Navajo Nation EPA, has identified 523 abandoned uranium mines. Of these, early cleanup actions have already been taken at dozens of mine sites. This includes the Cove Transfer Station in northern Arizona, where 22,000 cubic yards of contaminated materials were removed last year. This year, following community engagement, the EPA expects to select remedies for 10 cleanup actions within the eastern agency of the Navajo Nation. These include remedies for 2 major sites near the Redwater Pond Road community, the Northeast Church Rock mine site and the Quivira mine site, with each site involving the removal of more than 1 million cubic yards of material. Removal of these volumes of material raises challenges for transportation and disposal. To address that concern, the EPA is engaging with community members, as well as federal, state, and tribal partners, to identify transportation routes and disposal options. Of course, this work also entails significant costs. To that end, the EPA has entered into enforcement agreements and settlements valued at over $1.7 billion, providing funds to assess and clean up at least 230 of the 523 abandoned uranium mines on or around the Navajo Nation. Additional funding may also be available from the Superfund, especially for sites on the EPA's national priorities list, which may soon include the Lukachukai Mountains Mining District on the Navajo Nation. In addition to the Navajo Nation, many other tribes and indigenous communities have been impacted by the legacy of uranium mining in the United States. The EPA appreciates the concerns that we've heard today from members of the Oglala Lakota tribe, the Ute Mountain Ute tribe, and many others. We are aware of many similar concerns across the western United States, communities impacted by the legacy of uranium mining. These also include many pueblos in my state of New Mexico, including the Pueblo of Laguna, which is host to the Jack Pile Mine Superfund site. On his first day in office, President Biden signed Executive Order 13990, which provided Where the federal government has failed to meet its commitments in the past, it must advance environmental justice. At the EPA, we are learning from our past and looking to the future, working to deliver on our mission for protecting human health and the environment for all people, including tribal and indigenous communities impacted by the legacy of uranium mining in the United States. I thank the President and Commissioners of the Inter-American Commission on Human Rights for the opportunity to address you today, and I look forward to any related questions and discussion. Thank you.
Thank you very much, Ambassador Moore and representatives of the state. And now I turn to the Commission for any comments which you may have, and I will start with the Rapporteur on the Rights of Indigenous Persons, Commissioner Bulkan.
Thank you very much, Madam Chair. And allow me to begin by welcoming both delegations, representatives of the state, and to say that I take as an indication of your commitment to this process the very large delegation and representative delegation that you've brought, as well from the representatives of the affected communities. And I'd particularly like to acknowledge how happy I am to see representatives from the upcoming generation for whose livelihood this is all about. So this really pleases me to see, and I thank you very much. I think it would be very useful for us to begin, or for me to begin, by acknowledging some of the basic standards, which I know we're all familiar with, but just to lay the groundwork for what we're talking about here today, standards not just of our inter-American system, but also at customary international law, arguably. And I'm referring to, for instance, as observed in the Mary and Karidan case, which I'm sure you're very familiar with. It's been held by this commission that protecting the particular relationship between indigenous peoples and their lands and resources is linked to their very existence and thus warrants special measures of protection. These are basic standards that acknowledge the primacy of indigenous peoples in this region, and they're a measure of redressing historic injustices that involve removal from the land and continuing inequalities as a result of this. It acknowledges that failure to protect these standards and rights and to respect in particular indigenous use of their lands and their ability to live on these lands, whether because they're displaced, as we heard, or whether because of activities, mining concessions or whatever, inevitably subjects them to extreme poverty and precarity with risks to their life, integrity, and most importantly, a dignified existence. And so part of that protection and respect would include observing the FPIC principle, free, prior, and informed consent, as distinct from consultation. I'd like to acknowledge, and we've heard some of this today, about overlapping jurisdictions. But ultimately, as these standards acknowledge as well, the state's obligation is to ensure ultimately that its systems, however they are divided, are compatible with these minimum obligations. That being the legal context, as I see it, I welcome the information from the state about the presidential orders, the commitment of the present administration, and your own acknowledgement of the impacts, your very frank acknowledgements of the impacts, historic impacts of mining. I think that this is an excellent start. But reference in particular Mr. Newland's reference, acknowledgement of the impact of mining in general and the duty to consult. I'm curious as to whether your systems recognize more than the need to consult, but the need for free, prior, and informed consent as distinct from consultation, given the enormous implications that mining and other extractive industries have on the people living in the area, particularly as we heard here today. And if not, why not? We've heard at length about the various regulations and how they've been divided up between various agencies. But given the testimonies, the very moving testimonies that we've heard, there seems to be, at least to me, some sort of disconnect between these regulations and these practices and what's actually happening. And so one of the things I would be interested in learning is what accountability measures exist. So even though there might be these practices, are there any accountability measures where there's the failure to follow them or the failure to observe these regulations? And in that context, by accountability, what sort of reparations are provided to these communities? The agent from the EPA mentioned specific funds, and very large funds at that. I'd be interested to know whether they are available for these very specific cases that we heard about today. And more than cleanup and repairing damage, is there any provision? I'm not sure that I heard about any provision for benefit sharing. So cleaning up leaves us in the same position that we always were, or being reactive. But are there any provisions for benefit sharing with communities where these activities occur either on or adjacent to their lands? And finally, given your very frank, sir, your very frank acknowledgement of the impact of mining, and we've heard, of course, first-hand accounts of this, what kind of commitments would the state be prepared to make to reverse and mitigate this tremendous suffering that we've heard from communities today as a result of decades of these activities? Thank you very much for your statements and your testimony, and I look forward to your contributions.
Thank you, Commissioner Bulkan. Commissioner Ralón.
Muchas gracias, Presidenta.
Thank you very much, Madam Chair. I will be speaking in Spanish, and there is a simultaneous interpretation available. I'd like to begin very briefly by extending my greetings and a warm welcome to the representatives of civil society and also the illustrious representatives of the state. Ambassador Mora, thank you very much for being here with the delegation. I'll be quite brief, but I do want to ask two questions, one for the state and one for the representatives of civil society. I understand that certain statements have been made about very serious impacts on health, water quality, culture, that are not receiving a response, as the petitioners are saying. And the state has given us a very comprehensive description about some standards, some regulations, very robust institutionality to deal with these situations. So my question for the U.S. government, the state, is within this system, this institutional regulatory system, are there channels for dialogue? Are there coordinated measures at this time to deal with some of the effects that have been mentioned? And then my question for the representatives of the civil society. In practice, have you approached the U.S. government through the official channels for dialogue? Have you attempted any coordinated measures? And if you have, what has your experience been? So those are my questions. Thank you very much.
Commissioner Ralón, Special Rapporteur.
Muchas gracias, Presidenta.
Thank you very much, Madam Chair. I'd like to thank the petitioners for bringing this matter once again into the agenda of the Inter-American Commission for Human Rights. I want to also thank the distinguished delegation from the U.S. for its very complete and well-documented presentation. I'd like to mention a few aspects that Commissioner Volcan has also mentioned a few moments ago that are linked to the Inter-American legal framework and the standards within the Inter-American system. In particular, as relates to what has to do with the responsibility of the states in terms of exercising their regulatory responsibilities, as well as the responsibilities of private businesses in terms of respecting and protecting human rights to a healthy environment, the conservation of ecosystems and ecological diversity, paying special attention to how closely connected these are to indigenous populations, rural populations, and Afro-descendant populations. And I think we should mention that there's a consultative opinion of it's 2317 of the Inter-American Court that says that the states should prevent, regulate, and control environmental pollution in agreement with the provisions of the Inter-American system. So this interprets the American Declaration as well as the Human Rights Declaration. So I'd like to ask a question of the state, and I also have a request for the members of civil society. Regarding the state, I'd like to know whether, with respect to this particular case, beyond what is established in general terms by your regulatory system, for this case in particular, have you adopted or are you planning on adopting specific measures targeted at modifying environmental effects, reviews or assessments? And I would also like to look at a fundamental aspect of our democratic principles, which is prioritizing citizen participation in the making of environmental decisions, given that environmental effects can have a disproportionate impact on certain communities, in this case indigenous populations, and democracy plays a crucial role here in facilitating citizen participation in decision making. Is the state thinking of or trying to develop a better way to guarantee broader participation in environmental decision-making, in particular what's referring to these environmental impact assessment and the granting of licenses? Now for the group from civil society, the petitioners from our rapporteurship on desk rights, environmental, social, and cultural rights. We are particularly interested in this matter, and we'd like you to send us all the information you can to document this situation so we can take this into account in our monitoring work. At the end of the hearing, I'll give you the contact information for our rapporteurship so you can keep us informed even beyond this hearing today. So that's a question for the state and the requirement for the group that is petitioning us today. Thank you.
Thank you, Special Rapporteur Polemo. For my part, I want to thank representatives of civil society for bringing this issue to the Commission, and also for your representation here today, and of course to the representatives of the state. And I note the times that you spoke about the commitment to environmental justice, and I very much like the alignment of justice with the environment, because I think that's what we're talking about here, justice and rights. We have heard, and I want to acknowledge Ms. Edith Hood, we've heard from you, Ms. Hood, that the state, at the commencement of the mining of uranium in New Mexico, or so soon thereafter, the state knew of the risk of the mining. Not only of the mining, but also of the disposal of the waste which came out of the mining. They knew of the risk to the environment, and they knew of the risk to the health of those who were working within the mines and within the mills. Yet those risks were not disclosed to the workers. But the risk is not only to the workers, the risk is to the community, the families who lived in the shadows of these mines and these waste sites. So having regard to that non-disclosure, that historic non-disclosure, we also heard that there are high levels of morbidity and mortality which are related to the contamination of the land, of the soil, of the water, of the air. I think it's you said, how do you fight something you can't even see? So there's that contamination which is historic, but it also continues. My question for the state in this context, is there a compensation framework for those who suffered health debilitation from working in the mine? And also, is there a compensation or reparation framework for the families and the persons who lived and who still live in the areas where there is contamination? I should disclose I should give full disclosure that in fact I was in New Mexico in July of 2023 myself and former Commissioner Detroit Tina, and it is indeed New Mexico a startlingly beautiful place. It's such a different kind of landscape and really wonderful. But there were moments when the radiation in the atmosphere was being measured, and I understand, I don't know the science, but I understand a normal level of radiation in life here is around 6 or 7 or 8. And there were places where we went which were 13, which were 22. And I saw no signage about that this is a site that, this space, please don't visit. So my question really is about what is the compensation framework for the workers then and now who are still suffering, as well as for the families who live in the shadows and still live in the shadows of the waste. And also, Mr. Clifford Villa of EPA, I'm wondering, and I think you gave some statistics, but forgive me if I didn't get them all. I understand the range of the planning, the framework, the framework for regulation and for implementation of regulation. But I also want to ask, do you have a database? Is there a database on the number of sites, contaminated sites around the United States? And is there some sort of plan, time-bound plan about the remediation, the cleanup, or the removal of the waste? And on the removal, I suppose thinking forward, what is the half-life of uranium waste anyways? So you remove it from one place, you take it somewhere else, but it's not that it's safe in that other place unless it's not safe above ground, it's not safe below ground. And so I think this is a bit of a big challenge about how do you do that. So I just wondered if there's a database of the sites and also a kind of a time-bound planning for reclamation and remediation. Thank you very much. So with that, representatives of the civil society, you do have some minutes to respond. Let me see exactly how many, because I've forgotten now. 12 minutes on your side and 12 minutes for the state.
Thank you, Madam President, members of the Commission. This is Eric Jantz, the New Mexico Environmental Law Center. I'd like to address a couple of points the U.S. government made during its testimony. The first point is Mr. Newland talked about the sacrifices that indigenous communities made during the Cold War and before for national security. He also talked about the ways in which they look forward to indigenous communities protecting national security in the future. In my view, that sounds a lot like the U.S. government is expecting indigenous communities to sacrifice more in terms of uranium mining rather than addressing the problems that exist currently. I hope that's not the case, but it certainly sounds like that from the perspective of someone who's worked with indigenous communities for the last 25 years. In terms of Mr. Lubinsky from the NRC's testimony, I respectfully disagree with the assertion that public participation is encouraged and honored at the Nuclear Regulatory Commission. I worked with communities for over 15 years on a single adjudicatory hearing before the Nuclear Regulatory Commission on an ISL recovery mine. It cost the community millions of dollars. This was a community that is one of the poorest in the state of New Mexico and in the country. And that's often the case with indigenous communities across the U.S. So the Nuclear Regulatory Commission is asking the poorest communities to engage in processes that further marginalize them, in which they often aren't able to participate in the first place. Secondly, with respect to Mr. Lubinsky's testimony, there's never been an ISL mine that the Nuclear Regulatory Commission hasn't licensed. So there's never been a situation where there hasn't been, where they've seen enough danger to deny a uranium mine license. So I think that is not the view of a lot of the community folks that live near ISL mines and uranium mills. In terms of Mr. Villa's testimony, Professor Villa's testimony, I certainly appreciate and we're grateful for the most recent steps that the EPA has taken in some cases. Unfortunately, it's too late in a lot of cases. There's a graphic in the written materials that we've submitted to you that has very instructive in terms of how the EPA's progress has gone. In Navajo Nation, there are 524 abandoned uranium mines. 0 of them have been fully cleaned up. 4 have been taken interim cleanup measures. But at the pace we're going, it'll be another 100 years before there's full remediation. In addition, the EPA has been sitting on some ISL mine regulations for the last 15 years or so. It's a puzzle to us why those haven't been promulgated yet, but we urge the United States to do that. Thank you.
Hello, my name is Carletta Talusi. I'm from the Havasupai tribe. My tribe has been fighting this uranium mine proposal for many, many years. And to answer some of your questions, we have written numerous letters to the state agencies and the federal agencies about how they are continuing to permit Piñon Plain Mine, even though they have been operating on an old environmental impact statement that was approved in 1986. And we've been asking them to change and update their environmental impact statement. The Forest Service has not properly consulted us. When we ask for enforcement and oversight for Piñon Plain Mine, they say that EPA does not have a jurisdiction, the state doesn't have a jurisdiction, and all EPA says is that it's up to the state of Arizona to determine the permitting process. At this time, there's no enforcement and there's no oversight. And we have been diligently participating in consultation processes. They hear our voices, there's no response. They don't come to our communities. We have to travel to do these testimonies. We have to spend our resources to show up as a tribal government. There is no plans for proper transportation that is going to risk the public in this particular case with Piñon Plain Mine, and an accident is waiting to happen. And we have been diligently as a tribe to participate in all the processes as we possibly could, and we never get a response back. Thank you.
I just want to make a response to the Nuclear Regulatory Commission, and you have actually come out to our community and you experienced the wind at 40 plus miles an hour, and you actually got to see how the community has to deal with the material that was previously pushed into a mining area where it just blew right over all of us. And your response to that was to just leave it there. And that's, that's really disheartening for the whole community. And because we want offsite removal, we want it to be away from our community where we don't have to deal with that. It's really unfair that we have to deal with this, and my children have to deal with this, and later on my grandchildren have to deal with this. Why is the government just feeling like we're disposable? We're not. And I just want to put that out there. Thank you.
Hello. I wanted to address the NRC here and also the EPA. When we're dealing with, I'll start with Dewey Burdock. When we're dealing with Dewey Burdock, it's never been looked at as a Superfund. And all that runoff, there's a lot of abandoned uranium towns there, Igloo, Provo, and Dewey and Burdock. And we've been trying to get that looked at as a Superfund, and it hasn't been. They won't even allow, the project manager won't allow the EPA on that land just to look at it. So that's an issue in itself. And when we talk about the ISLs, like every place you go look for a spring coming out of that White River Group aquifer is contaminated. And my part is like, they always give us tests back and they say they're natural occurring uranium. Well, we want more radionuclide testing. We lack that. And we lack the evidence how those different isotopes are infiltrating our body when we're doing ceremony, because when we're on the ground, Crow Butte, every year we go back there. We camp there. There's many different tribes that go back there. And that's like Devil's Tower. The first acid leach uranium mine in the country is right outside of Devil's Tower. And we still go back there every year. And I tell my people, how it is. It's contaminated. And they don't care. And so that type of methodology, that type of house survey, that ceremonial use house survey has to be brought in. And that is always ignored on how those impacts are getting in our bodies. And this is my daughter that was sitting beside me earlier, and now we have to take her back out there to do those same ceremonies. And that's like, as mothers, as grandmothers, that's what we face. How are we supposed to be bringing our children into these ceremonies that are radiating, And the very important part about where I come from is like, we're the people that have over 100 sweat lodges. And Hoopa Valley has this great water quality standard that addresses that. And our tribes lack that. But we're the tribes that have those sweat lodges, Crow Butte water, all this water coming out of the Potter River country. I just wanted to read off these uranium mines up there. Lance Ross Mine, Iroquois Christensen Ranch, Nichols Ranch, Moore's Ranch, Smith Highland Ranch, Reno Creek, Ludman, Shirley Basin, Lost Creek. And those are all our territorial boundaries. And we still go back there. And they still ignore us. Thank you. I didn't say anything about eliminating NRC.
Hi. My name is Yolanda Babak. I'm from the Ute Mountain Ute tribe. That was my son that was sitting here that gave our testimony. Thank you guys for listening to us, for our testimonies, that we're all here, we're all different tribes, but we're all unite with one another, and we're sister tribes here. And I'm gonna let you guys know that, how I feel deep down inside me, how I feel living near a radiation, near a mill. I lived there all my life. I went being transported on a bus to high school, grade school, and I'm still there. I raised my kids there. Now our future generations being transported the same way I was transported to Blanding. We're like only 5 miles south of downstream from the mill. We have in our community, we have well water. Our well waters are north of our reservation. And all the contaminations and everything, that the cleanups and everything are being brought near our reservation. And that's not something that I want. I want our community to be free of radiation. I want our kids to grow up in a good environment to where they won't have to be suffering like the way how we are suffering to this day. And I would like, to let you guys know that I myself, when I was a little bit younger, I went to the NRC Radiation Control Board in the state of Utah in Salt Lake City. I approached them, me and my mother, but my mother's not here with me today. We approached them, we asked them these questions like, if there was any kind of disaster that happened there at the mill, what's the first town that's going to be contacted? What they told me was Blanding. Blanding's north of the mill. Then they told us the second town that's going to be contacted is going to be Bluff. We're right just 5 miles south of this mill, and we weren't even on the map. Our little community was not on the map. And that really hurts me really bad to see that they're overlooking us. It's just a small little Ute Mountain, a Ute reservation that's just south of the mill there. And our kids are being transported daily, on a daily basis. Our community don't have transportation. They hitchhike to go and buy groceries.
I'm so sorry, Ms. Yolanda.
Thank you guys
Badback.
for listening to us.
Thank you. And now I turn over to the state.
Thank you, Madam President. This is Francisco Moro, U.S. Ambassador to the OAS. We'll start with Assistant Secretary Newland, followed by Deputy Assistant Administrator Villa, and then Director Lubinsky in our response. Thank you.
Thank you, Ambassador. Thank you, Madam President. First, I want to, this is Brian Newland, Assistant Secretary for Indian Affairs at the Department of the Interior. I want to first acknowledge and extend my gratitude to the representatives of civil society and affirm that we understand the burden imposed on traveling to forums like this to speak, both financially and also just the physical toll it takes to travel repeatedly and share comments and views, and want to extend my gratitude to each of you. In response to the comment, responding to my testimony about future engagement in national security, it was a general comment about tribes participating in the defense of the United States, which is a long and rich tradition amongst many tribes to serve in the military forces of the United States and contribute to national security of the United States. And so that it was a general comment prospectively. With respect to the Commissioner's question about free, prior, and informed consent and consultation, the presidential memorandum issued by President Biden in 2022 setting forward baseline standards for the United States government on consultation included use of the word consensus, and that agencies engaged in consultation must work to achieve consensus with tribal nations as they're engaged in policy making, which was a large step forward from the United States' first endorsement of the United Nations Declaration on the Rights of Indigenous People. At the Department of the Interior, that phrase and that term consensus is also included in our agency consultation policy, and our obligation to seek consensus is greater as we get closer to tribal lands and the health and physical impacts of tribal citizens within their homelands. And I want to add on top of that that the Department of the Interior recently promulgated new regulations under the Native American Graves Protection and Repatriation Act. While not relevant to uranium mining, that those regulations explicitly use the phrase free, prior, and informed consent when it comes to the research on and display of remains, sacred objects, objects of cultural patrimony, and other items subject to that law. And so we are seeing, I think, improvements in that regard. And then lastly, with respect to the Commissioner's question on whether there is a forum or a venue for coordination across agencies on matters like this, the President has established an internal body within the federal government known as the White House Council on Native American Affairs. And that body is co-chaired by the Secretary of the Interior and the President's Director of the Domestic Policy Council. And I participate in that body, and it is comprised of agencies across the federal government to make sure that we are coordinating on policy development and actions affecting tribal nations and tribal citizens, and that on things like consultation and treaty obligations, that there is a venue where federal officials such as myself at the leading edge of our trust and treaty obligations have an opportunity to educate colleagues on the President's standards for consultation and other federal initiatives, and ensure that agencies are working together on matters such as this. Thank you.
Madam President, Commissioners, thank you for the thoughtful questions, and I will attempt to answer as many as I can and time allows. And thank you to the requesters for this hearing. It certainly shows the value of this opportunity to listen, and I would really welcome more opportunity for following up on more specific questions following the hearing. Commissioner Bulkin, you mentioned a number of important items, including the idea of benefits sharing. We do have a lot of funding available at EPA through settlements. They're dedicated to cleanup, and we are talking about a lot of heavy-duty construction. Imagine thousands of trucks that will be required to move materials. The funding that we have that's available for cleanup is not for compensation for past injuries, unfortunately. There's other sources, and I'll talk about that in a moment. But other ways that we might approach the values of benefit sharing include things such as jobs programs. What we're talking about are a lot of construction work, and we want to make sure that the people who have suffered these injuries also have the opportunity to participate in cleanup of their own communities. We want to provide job training. We want to make sure that that work is being managed locally, and keeping those resources in the community as much as possible. We also have other funding outside of the Superfund program. Another program in the United States is known as the Brownfields program that provides funding for cleanup and restoration planning in other communities too. We recently had additional funding in the Brownfields program. That is a program of grants that communities themselves and tribes can apply for. Unfortunately, we have found that it can be very challenging for some communities to go through those grant application processes. We understand that concern, and we're working on it. One of the answers to that is what we're calling a new program called the TICTAC, Thriving Communities Technical Assistance Centers, having real people who can help community members navigate the program to get resources where they need to go. In New Mexico, there is a real live person whose job it is, the TICTAC. She's based at Las Cruces, New Mexico. I met with her in December, and she understands the important responsibility of helping communities connect to federal resources to improve their communities. And we really look forward to the success of that program as well. Commissioner Ralón raised a number of important questions, some concerning how we adjust for differences and appreciation of culture when we do our work. And I think that's a very important question for us as well. We need to see communities as rich and diverse and values in many different ways. I could say that we are working on it. One of the cases that EPA supported actually came from New Mexico. It was about how we set standards for water quality in the Rio Grande that runs through the state. And the EPA fought and won a decision for the Pueblo of Isleta, which is the receiving end of contaminated water. And the Pueblo of Isleta had standards for ceremonial use that were protected in court. And that is the kind of respect we want. when we think about how we do environmental protection. I also had the recent experience of traveling to Hawaii, the island of Maui that had devastating wildfires last year. And EPA had a significant role in doing cleanup after those fires. And we worked with cultural monitors, we worked with Native Hawaiians to help us do our work better. And they taught us many things about the island, about their work and world. And in fact, we're taking lessons from many communities now. We need to be open to learning from communities. And when we think we're helping, we know that they may be helping us far more. When President Clark mentioned compensation, a very important question as well. There is a law, the Radiation Exposure Compensation Act, that is designed to provide compensation to some of the workers in particular who have been injured from uranium. We know that there are many people who don't believe that act goes far enough. That is a process that is sort of committed to our legislative branch, but we hope and trust that that compensation will remain on the agenda. It is certainly an important consideration. There have certainly been significant losses, and that should always be considered. You asked about a database for contaminated sites. There are many databases, yes, and we could help you connect to some of that information if you need to. And finally, your question about the half-life of uranium waste. We are talking about very long-lived materials. My home state of Mexico now hosts one of the very few waste repositories in the country, known as the Waste Isolation Pilot Plant, that accepts some forms of radioactive waste. It took 20 years or more to develop that facility. It was very controversial at the time. There are very limited opportunities, frankly, for safe disposal of radioactive waste in this country. And that is a real and continuing challenge. Mr. Jantz raised the question about cleanup and the pace of cleanup, and that is spot on. If we imagine that we are going to be removing contamination from a community, we've already heard we don't want to place a burden on any other community when we move it there. And many of the communities around the Navajo Nation are other indigenous communities. We certainly do not want to create a problem for any other of their neighbors. We're looking hard at all opportunities for finding safe disposal options. We're looking hard at transportation options. How you move that material really matters. Those are some of the conversations that I'm involved in personally and will be committed to helping to address in the coming years. We heard many other concerns, and I would just say that I really welcome additional information. We have resources, we have people whose job it is to do site assessment, to look at these concerns, and I can help connect those people to the communities that really need help. So thank you for this opportunity to share our additional thoughts, and we look forward to further conversation.
Thank you for the questions. This is John Lubinsky, U.S. Nuclear Regulatory Commission. So let me start. We had a question about accountability and holding licensees accountable, and I will focus all of my comments on milling operations, not the abandoned mines at this point, because we don't have jurisdiction there. We do hold the operators accountable for the activities which they have been approved for. In doing so, we set regulatory standards before we would ever approve a license. Those standards are published either in regulations or in guidance documents, which are vetted for public comment, and we hold public meetings to receive input on the adequacy of those standards and have outreach to the impacted community about those standards. We only will license a site if it meets those standards. The comment came up that we've never denied a license application. Quite honestly, I don't know if that's true or not, or whether we've ever denied one, but I would say as we've gone through the process, we do ask a lot of questions from licensees about whether they're meeting the standards, how they're meeting the standards, what type of assurances we have, and licensees most of the time have modified their applications to put additional controls in place to ensure that they are meeting the standards that are established, and we will only issue that license if they meet those standards. If a licensee is not meeting those standards, we do have tools in place for enforcement. The strongest of which is we could revoke their license and require them to clean up the site and go through a full decommissioning. We could impose civil penalties as well on those licensees as they go forward. And then I see my time is out, but if you will indulge me for one last point. I did want to comment on how do we get outreach. I said we do that during the rulemaking process. We do it during establishing our standards as well. Also on specific licensing actions, I talked about multiple times that we have outreach, and I appreciate the recognition of the NRC coming out to Gallup for a public meeting. And I would add to that, we were out there long before the public meeting in April of 22. We, as part of our environmental reviews, while not required by NEPA to hold public meetings, we hold scoping meetings in the area where the action is taking place so that we can go to the communities. With respect to the activity that was discussed at the April 22 meeting, we held multiple scoping meetings beforehand to get information from the local communities. We traveled to the area to reduce the cost and ensure we could get more folks having input to us. We held potluck dinners and luncheons in the area to have more informal conversations. During COVID, we extended the comment period on the draft EIS. I believe it was the longest open comment period we had on a draft EIS. And we made sure that we addressed all of the comments in our final EIS so that everyone could see how we factored in those comments in making our final decisions before moving forward. And finally, I would note that the meeting that was referenced in April of 2022, I believe that was the first time the commission, our commissioners, had a field hearing in over 40 years and actually traveled out to the area rather than having a hearing at our headquarters in Rockville, Maryland. We actually traveled to the area so that we could actually see the site and engage with people, and it would allow for more people to participate in that hearing. Thank you.
So we've reached the end of the hearing. I want to thank the representatives of civil society and the representative of the state for this very thoughtful conversation. This is not a problem that will go away, thinking just about the half-life of uranium. And so we know that there has to be a commitment to centering the communities that live in the shadows of these mines, these waste sites, these mills, and to find some solution that makes sense to those communities because they are the ones suffering the health effects. And it must be quite an experience to wonder if you can drink the water, to wonder if you can breathe the air, to wonder if you can plant your tomatoes and your celery. You're raising something that is deep and deeply profound. And so, as I started off this hearing when I said we are celebrating the 65th year of this commission, the commission really is about listening to the peoples of the Americas and the Caribbean, speak to their realities, and to help the state through our technical advisory services to the extent that we have them, because these are complex scientific and social and economic issues, to help reach compliance with the standards. And I am heartened, again, by the phrase environmental justice. And we stand here as the Commission to continue to monitor the situation closely, to receive information, to pay attention, and also to communicate with the state as we need to submit the concerns of the communities that we're serving. Thank you very much to everyone, and I now declare this hearing closed.